Can you raise your right hand for me, please? Do you solemnly? All right. Court is calling 2025 C.
Welcome to another dramatic courtroom breakdown. Today we're diving into the case of Felipe Reyes. A tangled web of legal maneuvering unfolds as we witness his trial for serious charges, including possession with intent to deliver. The defense team is already off to a controversial start, asking to consolidate multiple cases. What's at stake here, and who's holding the cards? Stay with us as we explore the twists and turns of this riveting courtroom drama.
Please. All right, then this is 2025 CR 0000701 and 2025 CR 00070.
Now let's pause for a quick explanation on what consolidating cases really means. When a defendant faces multiple charges, the defense can request that they all be heard at the same time to avoid multiple trials. Sounds efficient, right? But it also raises the stakes. If all charges are tried together, a guilty verdict on one could seriously affect the others. What do you think about consolidating these cases? Fair or risky?
All right, so Mr. Reyes, your attorney is asking that these cases be consolidated, which means that they be tried together. Do you understand? Can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Okay.
All right, do you have any objections to these cases being tried together? All right, so then both cases will be tried together. And counsel, if you could, I will need an additional cause number, I should say, written on the election of punishment, the written sworn motion for community, request for community supervision. Yes, you submitted them separately, but when we do the jury trial, it's going to be all on one charge, and I don't want any record to be unclear if this is appealed. Yes. So if you'll just make sure you do that for the election for punishment and also for the written sworn motion for community supervision. Yeah. And also for the trial court certification. And if you want to, you can just, it's already been file stamped. So you'll probably have to do just another one since it's already file stamped for the record. Okay. All right. And Yaya, if you could do another trial court certification, and it's going to be both cause numbers. Yes. And Yaya, I don't know, do you need to do something specifically as far as judgments are concerned, if judgments need to be made since they're combining the two cases?
I'll have to ask before.
All right, because I know Odyssey has changed things.
Yes.
Right. So
This is where the case gets heated. The defense is making a bold move, arguing that the prosecution's witness list was late. But here's the kicker. Under Article 3914, the prosecution is required to provide that list 30 days before trial. The defense claims they didn't get timely access. This could be a game changer. Late disclosure of evidence can be grounds for exclusion. So what does this mean for Reyes? Can the defense use this to their advantage?
His due process rights under the 14th Amendment is under the due process rights to be some type of trial. And so we feel like since the state does extend to law enforcement officers, they have been in possession of this evidence for months. We just got access to, I believe it's a total of 6 videos as of today. Two more were uploaded while we were reviewing evidence with Felipe today. We were only able to get through 2 of them with our client. They are extensive, and since we did review them, we were able to actually identify some material in statutory evidence. And so that is why it's important to be able to have that time to review them.
State?
I agree.
No, I'm not asking whether you agree with their argument or not. I want to know whether or not you just uploaded videos or did they have prior access to them. That's what I want to know.
No, these recordings were uploaded within the past 4 days.
All right.
Here we see an intense moment. The defense is pushing hard, claiming they only got access to crucial video evidence just days before the trial. We're talking about videos that could make or break the case. But the state says these videos were uploaded just 40 days ago. So who's right here? Can this last-minute evidence shake the entire foundation of the trial? This tension is real and shows just how vital pretrial discovery is.
Notice of the state's witnesses, we did kindly file our test estimates got retained on this case. So at this point, I'm asking that the court exclude any of the witnesses that are on the state's witness.
Under 39.14, time of filing is not later than 30 days prior to trial. State's defense's request was made within the past 20 days. So that would seem to not comport with 39.14's requirements for the motions for the witnesses. Moreover, the witness list specifically applies to requests for expert witnesses rather than state's witnesses in general.
All right, that will be denied. Yes.
The Supreme Court did rule in the U.S. versus Harris that can you just, I'm sorry, here, can you put this out, please?
This is a critical moment, folks. The defense cites U.S. v. Cares, highlighting a Supreme Court ruling that stresses the importance of fair notice. The defense argues that late access to evidence violates due process rights. In essence, they claim surprise is unfair, and they're calling it out. Should the prosecution have been more transparent, or is this just a tactical move by the defense?
In U.S. versus Harris, which is what I was talking about previously, the Supreme Court did assert that it is essentially not limited to the defense's request for such evidence. It is anything that may be, the state does have a constitutional duty to provide anything that institutions right to. It's not strictly and then we did file that motion for witness necessity for the so it was 50 possibility for us filing it 30 days out, but it wasn't in a popular state. We've had this case for several months now. So that's another consideration I think the court can consider when deciding whether we're going to strike the witness except for the notice.
Any response, State?
39.14 is triggered by a request served upon the state. There was no request for 39.14 material served upon the state prior to this defense firm's becoming involved in this case. So they are correct that this information was not furnished prior to their filing of that notice. But under 39.14's own provisions, it only becomes operative until defense serves a request on the state. It wasn't done until they became involved.
Judge, and just further under Martinez v. State, I think that the crux of this provision is to delay any unfair surprise to the defense, and they've had access to the discovery of the prosecution guide and the videos, and so that gives them notice of any witness that we would intend to call in the trial.
All right, and that's denied.
Judge, so the next motion that I wanted to address with the court was that motion to require the state here the appointment in open court. So are we going to, I guess, run that this trial?
Well, my understanding, and this was done off the record in the presence of defense counsel. I'm sorry, in the presence of defense counsel, the state informed the defense that that was an anonymous tip, and that anonymous tip was done through Crime Stoppers. Is that correct?
Yes, that is what the detective responsible for this case told me.
So is there an informant in this case?
Here, we're witnessing the legal tug-of-war between the prosecution and defense. The prosecution is adamant. No confidential informants were involved. But what if the defense is right? What if there's a hidden witness who could make all the difference? This moment hinges on transparency, and the stakes couldn't be higher. Will the judge allow further questioning, or will the prosecution's claim stand?
Going backwards, because we may be entitled to know who that confidential informant is that we can use them to prepare for trial if they were able to or they know that information that is exculpatory or mitigating for my client. And at that point, it's going to be waived during the actual in-trial testing of that data.
Well, it appears to the court as what you're seeking is to have the benefit of cross-examining every witness before.
Now let's talk about the power of cross-examination. The defense is pushing for the right to cross-examine every witness, This is crucial, but the judge isn't so quick to allow it. The tension in the courtroom is palpable as the defense digs deeper, aiming to uncover any hidden details that could turn the case in their favor. Who do you think has the upper hand here? The defense or the prosecution's solid rebuttals?
There is no confidential informant. There's anonymous tip from Crime Stoppers.
Is that, I mean, we were also told by the state, there was also representations that there were not recordings for one of the officers in this case that the body on camera or no dash camera. The state monkey actually required them to inquire as to that. Well, then dash camera and body on camera for the officer that state previously they didn't have, they ended up popping up. So we have to be very careful with this case because of all the different parties involved and just taking that information at face value. I really do think it's only one officer, but you could also take the motion to suppress with that one officer as well. And in terms of the admissibility of all of this, because the appeals court have said that the trial court is right to determine a state refusal to identify the informant, where the officers either claim that they no longer have the informant's details or agree that the informant has the state's.
But they're saying they don't have an informant. So the fact, what you're presenting to the court, stating that there are specific reasons for the court to grant the release of an informant's identification, they're saying an informant does not exist.
That's what they're saying. That detected here to actually confirm.
All right. So is there anything else? All right. Are the jurors outside? All right. Each side will have 30 minutes. This is the court's question. Yeah.
Yes.
Do we have the indictment in each of these cases? Are they here? Let me see. I don't know why I have So that's that. Let me see if I can find it. This. All right. So are you all proceeding on both counts in each indictment?
Yes, sir.
Yes.
As we reach the conclusion of this tense courtroom battle, the case of Felipe Reyes is far from over. We've seen procedural missteps, heated exchanges, and complex legal arguments. Ultimately, the judge has ruled. Motions for continuance and exclusion of witnesses have been denied. But what does this mean for the outcome? Will the defense manage to expose a critical error? Only time will tell. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.